Okay, take four. Welcome to the quadruple D. So, before I get to the main segments of the episode, to start with, I want to quickly mention that the FBI has raided the election office in Fulton County, Georgia, at the behest of the orange tinted idiot Donald Trump, who is trying to boost his lies about the 2020 election. And as he tries to actually rig the 2026 midterms and beyond. So, regarding the 2020 election, Rob Pitts, the chairman of the Fulton County Board of Commissioners, said at a press briefing every audit, every recount, every court ruling has confirmed what we already knew. Our elections were fair and accurate, and every legal vote was counted. And he continued, these ongoing efforts are about intimidation and distraction, not facts. And he also noted that the FBI seized 700 boxes of materials. So, with the boxes, it reminds me of the uh, documents that Donald Trump stole, the classified documents, which he was never held accountable for because, Merrick Garland is you know, whatever. Nothing was done about that. So anyway, the FBI raid is ominous, but the main story I am focusing on today is that journalist Don Lemon was reportedly detained by federal agents on Thursday night in Los Angeles, where he was covering the Grammy Awards, according to a statement from his lawyer. The lawyer stressed that Lemon has spent 30 years in journalism and that what he was doing in Minneapolis, reporting on protest activity, fell squarely within First Amendment protections. The First Amendment exists to protect journalists whose role it is to shine light on the truth and hold those in power accountable, Lowell said early Friday. That means this morning, on the day that I'm recording this episode. So, earlier this month, Lemon had traveled to St. Paul, Minnesota to document some anti immigration and enforcement office or and customs enforcement activists or anti ICE activists who entered City's church during a service. Protesters there were confronting the increasing federal presence in the Twin Cities tied to Operation Metro Surge, and there was apparently somebody working who is prominent in that church who is involved with ICE. And of course, ICE have had a massive deployment, and that is something that people are really focusing on right now in Minneapolis, Minnesota. Of course, criticizing the aggressive and sometimes deadly tactics they are employing. And in the footage that Lemon posted on YouTube, he insisted he was just here photographing and not participating in the protest itself, which is, of course, something that journalism entails. You cover the story, sometimes you have to be there to cover it. So he stressed in the video footage, I'm not part of the group, I'm a journalist. He says that to the officers and observers on camera. Journalists have historically faced police impediments while covering protests, particularly when law enforcement claims private property rights trump press access and things like that. So, federal officials have publicly stated that Lemon will be charged, arguing that he had no right to be inside the church and that interrupting a service could violate worshippers' rights. So, whether prosecutors will pursue these claims, especially given broader controversy over federal force in Minneapolis, is unclear. But what is quite clear is that there is strong precedent here for what Lemon is doing. The arrest of Lemon has been framed by his attorney as a politically motivated distraction from more serious accusations against federal enforcement. So, Lowell, the lawyer here, said that instead of investigating the federal agents who killed two peaceful Minnesota protesters, the Trump Justice Department is devoting its time, attention, and resources to this arrest, and he called the action, quote, an unprecedented attack on the First Amendment, end quote. Well, unfortunately, I have to disagree with that because there is precedent for these sorts of attacks on the First Amendment. And just to be clear, the press is so protected traditionally that even the media people who were there covering uh, the January 6th insurrection, the breach of the Capitol, even they tended not to be charged if they were able to prove that they were not, willfully participating in any violence. So, that's they might have still been charged, but they would have at least received a reduced sentence, maybe a fine or something like that. So those two killings, of course, people know about them pretty well. They've been widely reported and documented. On January 7th, 37-year-old Minnesotan Renee Nicole Good, a U.S. citizen and community observer of ICE operations, was fatally shot by an ICE agent during a federal enforcement action in Minneapolis. Now they will call them things like federal enforcement actions, but it's really just people acting uh, like thugs, like cavemen. I mean, if Trump has his way, basically the entire country will end up looking like a bunch of cavemen and just beating each other with sticks and uh, you know we'll further de-evolve to the point where the only way we can address issues is through violence. That really goes with what I've said about Republicans for or before. Their primary way of dealing with issues is to shoot them, bomb them, beat them, throw them in a cage, or just completely take away their resources, starve them of resources, and that's how they deal with any sort of social issue. So federal officers here have claimed that the agent acted in self defense, and that's because they say that Good's vehicle moved toward him. But if you look at the video footage, her steering wheel is clearly moving away from him, and he was actually leaning into the vehicle to shoot her. And, the video evidence and eyewitness accounts have contradicted the Trump regime's narrative on this, and the Hennepin County medical examiner ruled her death a homicide, which it plainly was. And just over 2 weeks later, on January 24th, another Minneapolis resident, ICU nurse Alex Pretty, was shot and killed by federal agents during the same surge of immigration enforcement. Human Rights Watch and news outlets have documented the incident with multiple independent videos. Pretty was reportedly unarmed, but he did have a holstered gun, and he was not posing a lethal threat when agents fired on him. And those shootings sparked tens of thousands of protesters in Minneapolis and beyond, across the United States and probably in areas around the world. And you'll hear slogans like abolish ICE and ICE out for good. I personally like the slogan just about ice needing to melt away or something like that. It's a little bit more poetic. But anyway, local political leaders, including Minneapolis Mayor Jacob Frey and Minnesota Governor Tim Walz, have condemned the federal use of force and questioned official accounts of both deaths. And federal judges in Minnesota have even restricted ICE from detaining or using chemical agents against peaceful protesters not interfering with operations. Attorney General and Epstein cover up specialist Pam Bondi, during a recent visit to Minneapolis and an interview on Fox News, labeled the church protest horrific, but did not specifically address Lemon's arrest. And she also did not address the mounting evidence that those two people I mentioned were outright murdered, because that's what she is involved in trying to conceal. The Trump administration does not want, the evidence of those cases to be examined. They're protecting the ICE agents, and they are willing to sacrifice their own legitimacy in the cause of protecting their fascist impulses here. And there's a broader political framing that focuses on property rights and public order rather than the existing crisis over lethal federal intervention, and the fact that ICE is just acting with total recklessness and trying to have absolute immunity, which is what J.D. Vance has said that these ICE agents have. Well, they don't have that. In fact, that's him just attempting to make up the law on the spot. You can be charged if you are a federal officer. It's just people like J.D. Vance are admitting what they want, which is a completely illegitimate government that can do whatever it wants. It can do any sort of violent abuse, any sort of violation against the U.S. population. And frankly, this is what happens when you give people like President Trump himself near absolute immunity. And I'm going to get into that with my next segment where I talk about John Roberts. And these events, they really reflect how state power through agencies like ICE and the DHS uses legal and extra legal force to suppress dissent and to control and to demonize and ultimately suppress political movements that would question their right to have absolute power. ICE is a deeply controversial agency, and it was even before Donald Trump, mind you, although it wasn't quite as widespread of a controversial agency. The critiques weren't as widely uh, available in the media, and the scale of their atrocities wasn't quite as blatant. And, they have a long history of detaining and deporting migrants without substantive due process, and its ramped up deployment to Minneapolis has brought that history into direct conflict with community responses. A lot of the valid critiques of these organizations emphasize that when federal power is unchecked, it frequently deploys violence against marginalized people and seeks to marginalize other people, including just critics in general, and also legal observers and even journalists, all while claiming legality through property and public order justifications. So, whether Lemon's arrest will stand up in court or whether broader scrutiny of federal force will lead to policy change and accountability for the deaths of Good and Preddy, well, that remains to be seen. But the situation reveals long-standing tensions between these grassroots resistance and state power, and the ways that journalism, protest, and repression can intersect in the fight over narratives and rights. So I know one of the things that the right wing media is doing right now is they're claiming that, oh, these are not grassroots protests because there are these organizations and some funding involved. Well, give me a break. There's enough grassroots pressure involved here, you dipshits. And, they're just looking for any excuse to sort of invalidate the response to these ongoing atrocities. And another common tactic you'll see is that, well, it's not as bad as you could possibly imagine. So maybe look the other way for that excuse too. Well, it's going to get worse. It's only going to get worse unless the people step in and, you know, for one thing, document these things, but also you need to protest. And in some cases, like today, there's supposed to be a general strike, a nationwide shutdown. And I am kind of participating in that because I'm not going to be buying anything today. But basically, a national, I was going to say national and nationwide at the same time, but a national, a national strike. I repeated that again. But anyway, a big strike is intended to, you know, basically shut down the economy and force people to understand the power that the citizens still have, because really the power of the purse is really one of the main powers that the American citizens still have. Although paradoxically, the power has always been within us. And, that's one of the quirky things about the nature of power. Like, we, for some reason, give power to these people in these positions. And it's weird because we actually have the actual power. But at the end of the day, people need to realize that. And one of the ways of realizing that is to put your money where your purse is, so to speak. So, admittedly, if I had to work today, like, it's just a coincidence that I have the day off from my day job. But if I did have to work today, I probably would have gone in. I mean, I hate to admit it, but I would have tried to not spend money in stores or anything like that. I figure I can get away with that for just one day. I've got some food in the freezer, so that's going to be all right. I can make some tea or whatever. So this is basically the least I could do other than broadcast my critiques of what's going on through my podcast. So, all right, I'm moving on to the second segment of my show, which I call the peripheral poop head of the week normally. Although this person isn't so much on the periphery, so I guess they're just the poop head of the week. I'm talking about Chief Justice John G. Roberts Jr. So on January 20th, 2017, I was going to say 1917, but that would have been 100 years, over 100 years ago. But anyway, on January 2017, the constitutional oath that inaugurated Donald J. Trump as president was recited with Chief Justice John Glover Roberts Jr. administering the oath of office, a ceremony rooted in the rituals of state power. And of course, as Trump has demonstrated, he does not care about the U.S. Constitution. So he lied under oath, basically. And I'm going to get into some of his lies, some more of Trump's lies below, and also the lies about Donald Trump. So, John Roberts, he was born in 1955 in Buffalo, New York. He was born on January 27th, which was just a few days ago. So, oops, I guess I missed an opportunity to make this a birthday themed episode about him. But anyway, he has been the 17th Chief Justice of the U.S. Supreme Court since 2005. He was appointed by President George W. Bush, confirmed by the Senate with a 78 to 22 vote. And in that role, Roberts leads the Supreme Court, the final arbiter of constitutional law in the U.S. Well, it's supposed to be the final arbiter in in a sense, but of course, the people of the United States are the actual final arbiters of what is constitutional or not, for better or worse. Like I said, the people have the actual power. But keep in mind that the Supreme Court is technically an unelected body that exemplifies concentrated judicial authority insulated from direct democratic accountability. Now, I've always called for a more direct democratic system. I challenge the premise that we actually need a president and all that kind of stuff. So I would like to see the U.S. government and the American society to be amended, and that should reflect the restrictions on presidential powers. And maybe we should not have a U.S. Supreme Court in the sense that we've known it. But that would, of course, conventionally require constitutional amendments and, of course, some activism and all that sort of stuff. But at the very least, I think we need some severe restrictions on presidential power because it's too close to being a dumbass dictatorship. So the U.S. Supreme Court is the highest federal court, and its decisions shape everything from civil liberties to corporate rights. And as I've said in the past, some traditional conservative arguments have been that we should not regulate corporations, but the problem is, if you do not regulate corporations, they end up regulating us. And looking at Robert's history, he grew up in the Northwest Indiana uh, area of the United States in a Catholic family. He went to Harvard University, where he finished a history degree in 1976. He then earned his law degree from Harvard Law School in 79, where he served as a managing editor of the Harvard Law Review. After law school, he clerked for Judge Henry Friendly and later for then Associate Justice William Rehnquist, who was a douchebag in many respects. So I'm going to look into Rehnquist in a little bit here. He's my next segment, actually. But before joining the bench, Roberts was a lawyer in the Reagan and George H.W. Bush administrations and argued 39 cases before the Supreme Court as part of a leading appellate practice in Washington, D.C. His career path from Harvard elite to federal judiciary is typical of U.S. power structures that recycle a narrow class of legal professionals through private practice, government legal work, and ultimately lifetime judicial appointments. So, Robert's judicial philosophy, or at least his stated judicial philosophy, has been described as institutionalist and moderate conservative, although what moderate means is really up to debate. But anyway, he's stressed in the past that judges should apply the law rather than make it, a metaphor he expressed at his confirmation. Quote, "Judges are like umpires. Umpires don't make the rules, they apply them." End quote. Yet his tenure has coincided with, and in many cases helped advance, a far rightward shift in U.S. constitutional law that critics, like myself, argue entrenches elite power and rolls back protections for marginalized groups. That's often what they would say is just us enforcing the law as written or whatever. So, under Roberts, the court has issued several controversial rulings, many of which have expanded executive and corporate power while weakening social protections. So, you had the National Federation of Independent Business versus Sebelius from 2012. In that one, Roberts provided the decisive vote to uphold most of the Affordable Care Act, Obamacare, by reinterpreting the individual mandate as a tax. Conservatives criticize this as judicial overreach despite blocking its constitutional basis under the Commerce Clause. Now, keep in mind that in addition to having conservative critics, a lot of liberals and progressives also criticized Obamacare for the simple fact that it uh, was really a gift to the insurance industry. So, why was the Commerce Clause aspect important? Well, Roberts, along with the four other conservative justices, concluded that the individual mandate was not a valid exercise of Congress's power under the Commerce Clause. The court ruled that the Commerce Clause allows Congress to regulate existing commercial activity, but does not empower it to compel individuals to participate in commerce, such as by buying insurance. And interestingly, car insurance is not federally mandated in the United States, as regulations are set and enforced at the state level. So a lot of people, they would say that, you know, the individual mandate should have been considered valid because car insurance is considered valid as mandated by states, but the weird little loophole is that it's not federally required. So yeah, that's a bit of a weird little legal dispute here. So Shelby County versus Holder from 2013. In that one, Roberts' majority opinion invalidated key provisions of the Voting Rights Act of 1965, arguing that conditions that once justified federal oversight of elections no longer characterized voting in the considered jurisdictions, and that's a quote. And of course, critics argue that this ignores ongoing systemic discrimination. So their criticism of the decision is, they argue that the majority opinion ignored or was oblivious to the reality of ongoing, often more subtle, second generation voting discrimination like redistricting or voter IDs laws. And Ginsburg had a dissent, Justice Ruth Bader Ginsburg. In her sharp dissent, she famously argued that removing preclearance was like, quote, throwing away your umbrella in a rainstorm because you are not getting wet, end quote. She argued that the very success of the VRA in stopping discrimination was being used as a reason to dismantle it. And another critique is that it's shifted to a whack a mole sort of thing. Without preclearance, critics argue that challenging discriminatory laws has shifted from proactive prevention to reactive litigation, making it a whack a mole game where new disciplinary or discriminatory laws pop up as soon as others are challenged. And there was an immediate negative impact within hours of the ruling. Jurisdictions previously covered by the formula, such as Texas, Mississippi, and Alabama, moved to implement voting changes like strict voter ID laws that had previously been blocked or likely would have been blocked. So, there's been a rise in disparities. Research indicates that in the years following Shelby, the racial turnout gap grew faster in previously covered jurisdictions than elsewhere in the nation, and thousands of polling places were closed in minority heavy districts, which is, of course, an attempt to freeze them out of elections, or at least make it much more difficult to vote. So, the legal status post 2013, Section 2 remained, but they're trying to maybe find a way to get rid of that won't be generating that much controversy. The decision did not strike down Section 2, which allows for nationwide challenges to discriminatory voting practices. However, this requires victims to sue after a law has gone into effect, a process that is costly, time consuming, and difficult to win. So, congressional action wise, the Supreme Court explicitly invited Congress to draft a new formula based on current conditions, as they call them. So, as of early 2026, Congress has not enacted a new formula despite ongoing efforts to pass legislation like the John R. Lewis Voting Rights Advancement Act. So, another case under Roberts is the Trump versus Hawaii case from 2018. There, Roberts wrote the majority opinion that upheld Donald Trump's travel ban targeting primarily Muslim majority countries, giving wide deference to executive discretion over immigration enforcement. So the court ruled that if the enforcement of the Immigration and Nationality Act grants the president broad discretion to suspend the entry of any class of aliens deemed detrimental to the interests of the United States. And he even said that Roberts said that the statute exudes deference to the president in every clause, end quote, concluding that the proclamation was well within the authority granted by Congress. So the national security justification is, of course, it's a goofy uh, way of framing anything that the president wants, basically. The majority found that the administration provided a sufficient national security justification rooted in a worldview or a worldwide review of information, sharing protocols for the restrictions rather than acting on anti Muslim animus, which is a little bit silly. I'm going to get into why that's silly. Basically, it's because Donald Trump has been explicitly anti Muslim on a ton of occasions. So the idea that this wasn't having anything to do with anti Muslim animus is laughable. I mean, it's tragic, but it's laughable. And the court rejected the argument that the ban violated the Establishment Clause of the First Amendment, finding it was facially neutral and not motivated by religious animus. That's despite Trump famously demanding and I'm quoting now, total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on, end quote. So he worded things very stupidly there, and he made it explicitly clear that he is seeking a Muslim ban. Then you have other Republicans like Randy Fine, who's anything but fine, tweeting his own anti Muslim craziness. He said, "There is no suffering adequate for these animals," referring to Palestinians. "May the streets of Gaza overflow with blood." A just plainly almost satanic sounding choice of words. And Randy Fine also says Gaza must be destroyed. He also called for them to be nuked, literally nuked. And so, yeah, there's no noteworthy Islamophobia from the GOP, according to the U.S. Supreme Court under John Roberts. Now, of course, those Randy Fine quotes, a person might point out, well, those were after uh, the case in question, and sure enough, but there were other quotes that were plainly Islamophobic, so you can tell pretty well that the Republican Party is Islamophobic. And like I've noted several times on this podcast, it's not like I'm pro-Muslim myself. I'm actually an atheist, but there's a difference between being a secular atheist and being, somebody who wants to actually ban religions. I don't believe in banning Christianity or Muslims or any number of other religions, despite the fact that I might disagree with them in some fashion. You know, that's not what secularism is about. But Donald Trump made it plainly clear that he is not interested in secular government, and neither is the MAGA movement in general, which is frankly infested by religious theocrats and fascist types of uh, organizations and individuals. So, interestingly, in his opinion, Chief Justice Roberts formally repudiated Korematsu versus the United States in the case from 1944. I was going to say 94. But then, anyway, that case had upheld the internment of Japanese Americans during World War II, and Roberts stated that the decision was gravely wrong the day it was decided and had nothing to do with the Trump versus Hawaii case. Well, this is despite we know that the United States government has been trying to have internment camps for basically any group that Republicans don't like. That would include, of course, Muslims. And as we saw during the George W. Bush administration, there were Muslims who were sent off to Guantanamo Bay and sometimes tortured by the US government. That famously happened at Abu Ghraib, where we learned about their enhanced interrogation techniques and stuff like that. And of course, right now they want to not only go after immigrants and put them in these, I guess, concentration camps or whatever. And they're not only doing that with immigrants, but they're also trying to target Native Americans again. So that is being revamped under the Trump administration. And regarding the anti-Muslim case here, Justice Sonia Sotomayor and Ruth Bader Ginsburg filed a strong dissent, arguing that the court was blindly endorsing a policy motivated by religious animosity and failing to safeguard fundamental religious liberty. The dissent argued the ruling redeploys the same dangerous logic as Korematsu. So I think they were right, these two justices. And even though I criticize the U.S. Supreme Court, it is still refreshing to see that there are some justices who do dissent with these more overtly fascistic decisions, such as the idea that we should ban all of these different groups from entering the United States from foreign countries. You know that should actually be, in this case, considered a violation of constitutional rights because Donald Trump repeatedly made it explicitly clear that he is interested in targeting Muslims. So there's also Trump versus the United States of 2024. In that one, the court ruled that presidents have robust immunity from criminal prosecution for official acts, effectively shielding Trump from legal consequences during his second presidency, which also emboldened Trump during his reelection campaign. If they had not made that decision, and if they had decided differently and suggested that the presidential powers should be limited in some way, well, then that would have actually potentially given Donald Trump less confidence in terms of acting like an authoritarian. Now, of course, Donald Trump still would have been authoritarian to some extent, but as we saw during his first administration, having guardrails in place and putting him psychologically in check actually matters. And what happens now in this administration, in the second go around, the Trump administration has basically thrown out the rule book. And by the rule book, I mean the law book. They don't care at all about the U.S. Constitution. They're willing to go after U.S. citizens. They tried to throw Jimmy Kimmel off the air effectively, although incredibly, the American people actually stepped up and they made it clear that they did not want him to be fired by the FCC for being a critic of the president. So that was a good thing. But when all is said and done, the reelection of Donald Trump was certainly emboldened by this idea that the U.S. president has near absolute immunity. So that's because the president could, they could just say anything is an official act. You could say that picking his nose is an official act. Obviously that's a zany example, but you could do that. You could say it's official, and then you would have to challenge any sort of uh, abuse of power in a court system, and who's to say what's official and what isn't? Who ultimately gets to decide that? Well, when you say that the president has near absolute immunity, how do you even decide what those limits are? So, of course, it is essentially the case that he has been given the right to get away with practically anything, and that's what he's been doing. And these decisions have real consequences, weakening voting rights protections, expanding executive powers, and reducing avenues for accountability. These are patterns that tied to state violence and systemic injustice, of course. And that's not to say Roberts never departs from the conservative bloc. For example, in Bostock versus Clay County from the year of 2020, he actually joined a majority finding that LGBT workers should be protected from discrimination. And in the Department of Homeland Security versus Regents of the University of California, he constrained the Trump administration's attempt to end the DACA program. I mean, you have to wonder why he went the other way in those cases. It's almost like he just has a dartboard and, like, it kind of randomly decides what he's going to decide. I mean, that's probably not the case, but who knows? The logic is sort of all over the place here. And Roberts also has broader administrative authority over the federal judiciary and carries out ceremonial duties such as presiding over presidential inaugurations and Senate impeachment trials. So he has a symbolic presence as well that sort of gives the uh, clown president the appearance of legitimacy. All of these dumb ceremonies that these people in power do. It's all for show to give the appearance of legitimacy where there might not really be any or practically none. And that's an interesting component of all of this too, the pageantry involved. So Robert's role, he really highlights the undemocratic nature of judicial power. He's got a lifetime empowered of he's a lifetime empowered official. He's appointed by elites and confirmed by a political body. He shapes laws that constrain power among the population. He violates the popular will and reinforces hierarchies. That's basically what a lot of the federal government does in a lot of cases. And it's one of those things where it's a little bit complex because the old school argument would be that the popular will is not always right, and that's why we have a constitution in the first place. And maybe there's some truth to that, but at the end of the day, the U.S. government is actually supposed to serve the people. So you've got that fundamental contradiction there. Well, if it's reinforcing hierarchies that actually harm the people in many ways, well, that's not really the popular will, and that is actually in defiance of the U.S. Constitution, based on its own stated premise of representing the people. And if the Congress and the Senate are compromised and they're basically in power there to, I guess, bolster the president who has absolute immunity and who can do things like trying to cancel elections and stuff like that. Well, where does that leave us? You don't have true representative government when that's the case. So anyway, that's about all I need to say about Roberts at this point. I think I've gone into that well enough. He's sort of there to mask the distance between governing institutions and everyday people by making himself look like he's just a neutral person interpreting the law, and if the law craps all over the population, well, oopsies, that's just the way the Constitution works. You know, it's all a weird game. It's all contradictory, and it's very hard to actually explain in a way that actually makes sense. So anyway, on to the third segment, which is I'm going to be looking at Justice William Rehnquist, who Roberts served as a law clerk for. Recall. So, the biggest and most concrete scandal involving William Rehnquist centers on allegations of voter intimidation in Arizona during the 1960 election, and it's the one that tends to matter most outside purely legal circles. You don't hear too often about these old school scandals because the media doesn't cover them that often. But here's what happened from what I understand, from what I've gathered. In 1960, Rehnquist was a young Republican lawyer in Phoenix. He volunteered as a poll watcher during the presidential election. Multiple witnesses later alleged that he aggressively challenged the eligibility of Black and Latino voters, forcing some to take literacy tests or discouraging them from voting altogether. So the issue resurfaced during his Supreme Court confirmation hearings in 1971 and again when he was nominated for Chief Justice in 1986. Rehnquist denied that he intimidated voters, saying he only challenged voters he believed were ineligible and that the accusations were exaggerated or false. The exaggeration was against him, not the voters that he challenged. So several witnesses contradicted him, including a former Justice Department lawyer who said Rehnquist had bragged about stopping minority voters. There was no definitive proof that settled the matter conclusively, but the record clearly showed that he did participate in organized vote challenges. Those challenges disproportionately targeted non white voters. His later testimony was at best selective and at worst misleading. Politically, he survived the scandal, but it's something that people remember. And institutionally, nothing happened as a consequence. So here's why this scandal stands out. Other controversies around Rehnquist, like his early memo defending Plessy versus Ferguson, or his consistent hostility to civil rights claims, are often framed as jurisprudential disagreements, a snappy way to phrase it. But the Arizona episode is different because it involves direct action against people and not just ideas. It's about who gets to participate at all in the voting process. So Rehnquist, keep in mind, if you're aware of this, that he had defended segregation by private businesses in the early 1960s on the grounds of freedom of association. But of course, none of these people who would argue such a thing would argue for the right for them to be singled out as people you can discriminate against. Like William Rehnquist would never say, "Oh, all of these businesses in this city that I live in, they would have a right to single me out and say that I'm not allowed to buy anything from any of these stores or whatever." He would never argue for the right of businesses to do that. Of course, it's always like this vague thing where you have to cast a wide net and say that, oh, these businesses have a general right to just not sell things to anyone that they don't like. The more specific you get, the more into detail, the uglier it actually looks. So, for people who defend the right of businesses to discriminate, I want you to think about it in that sort of way. What if all of these businesses, as like a thought experiment, what if they said they have a right to discriminate uniquely against you as a person? Forget about group identities or any of that kind of stuff. Let's just say all these businesses said, we're not going to sell anything to this person. We're not going to hire them. We're not going to even acknowledge their humanity in any way or anything like that. Would you actually want them to have that right? Would you want them to just force you into being an outcast? You know, so think about it like that. And that might help you better grasp the issues because when it comes to right wingers, they lack empathy. So they fail to be able to put themselves into another person's shoes. So that is really the most direct way that you can force people to understand what these issues are actually about. It's not about whether you love a certain group or hate a certain group. It's about whether you want businesses or other organizations to just say you have no right to, have access to grocery items or whatever. And I know there are some like if somebody actually commits a crime in that store or something like that, or whatever, then okay, there might be a reason on an individual level why you would ban somebody from a store. But that's a different sort of issue here. And of course, it's just obvious that Rehnquist was a piece of crap and that he was a bigot and that he wanted the right of segregation and discrimination. But you know, he would not have phrased it like that. So anyway, that's it for this episode, and I suppose there's a lot of food for thought here. A lot of people would disagree with what I'm saying, regardless of the content or how I phrase things. They might look at certain things that I said wrong, like I of course flubbed a number of words here and there, but I think the gist of this episode is pretty solid. So uh, yeah, that's about all I've got for this particular episode, and have a good day.